Hello, this is Attorney Mike Griffin coming to you from Chicago. As usual, the trial is over. We're waiting for a verdict. I don't have a verdict, but somebody had a good idea. We're just going to go ahead and watch Judge Manning until it gets there. But you guys have to tell me in the chat when we get a verdict, or we're just going to watch Manning. Let's do this thing, shall we?
All right. And then no, you're not getting out. I'll reduce it $75,000. Best of luck to you, sir. Thank you, Cobb.
Pre-trial.
Let's see. Do we have Cedric Williamson yet? The two Cobb gentlemen, y'all can let them know y'all can go. Cedric Williamson yet? Nope. All right. Bernard Duffy. Wave your hand if you're Bernard Duffy.
Judge, that case I had was being removed. It was going to be reset based on it being a conflict attorney that she emailed us about.
You're right. My man. Larry Gunn. There you go, Mr. Gunn. All right. This should be Mr. Anderson. Is he on?
Yes, Your Honor.
All right. This is position 21, Bostic 22 CP2 14434. Larry Jerome Gunn, 117 days without indictment, aggravated assault, no bond as of December the 5th. Free. Rah.
Larry Gunn, 30 prior arrests, 4 arrests for probation violations, 4 misdemeanors, 2 FTAs, 2011 terror, 2010 terror, 2010 attempt to kill, obstruct a witness.
All right. Go ahead, Mr. Anderson.
Excuse me, Your Honor. Yes, Mr. Gunn has been in jail for 117 days, no bond, no indictment. He is 49 years old, has lived in Georgia for 33 years. He attended Clark Atlanta University. He is homeless. We have a social worker working on getting him placement, probably looking for a drug program, hopefully. He has 5 adult kids and 5 grandkids in the area. He acknowledges he's had some prior failures to appear. That's largely just due to his housing situation or lack thereof. That would not be an issue if he were to get into a program. So, unfortunately, I do not have an update on the status of that yet, but, we would just ask for him to, pending on his admission into a residential program, to be released into that pending trial.
All right. What says the state?
Thank you, Judge. Briefly, the state would recommend $25,000, good bond. Obviously, no weapons, no contacts away from the incident location, and any other terms and conditions the court deems appropriate in this matter.
Oh, you said 25?
Yes, $25,000.
All right. All right, we'll do a $25,000 good bond, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3535 Peachtree Road. No further contact with Robert. I got Seagrest.
Yes.
Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and participation in a program if Mr. Anderson gets you in a program. So you can do that. You must supply an address before they let you out. One of your bond conditions, you have to supply an address to the jail. So if Mr. Anderson gets you into a place, he'll at least be able to give something there where your notices can be sent. They'll know which way where you'll be staying. Because some people give you temporary housing, and then after 30 days, they move you somewhere else. I don't know. This hold's still in out there, is it, Bostic? There's one on here on East Point on his booking sheet.
If it's still showing on his booking, then it's still there.
All right. If there is a hold, usually the case managers put you up 48 hours to get your ankle monitor placed on you after you get released from that hold. Best of luck to you, sir. Oh, we can also put employment, I guess, right, Mr. Anderson? It's part of some of those programs is get him employment.
I'm not sure the details, but we could put that as well. Yes.
Okay. Employment, if they get you a job through this program, sir, but you got to provide proof of employment, name of your employer, location, and your schedule. You have to supply that to the ankle monitoring company and Mr. Anderson. Best of luck to you, sir. You can leave the booth. All right. What about So do we have the conflict here for Keyshawn? What did we do with Keyshawn Wiggins? There's a conflict for that one, right?
It's not a conflict, Judge. I'm covering for Attorney Gordon.
Okay, Keyshawn. All right.
I'm in
Uh,
jail.
I know you want to wave sounding, and Bostic's, a champ at doing the right thing and she's smarter than most of us probably. This position 1, Keyshawn Wiggins, 22 CP 210728, 259 days without indictment. There is a $20,000 good bond as of November the 2nd. Pre-trial.
His position, what? Sorry.
It's what the add-on calendar, Bostic.
I don't have
One
that.
on the add-on.
My add-on number 1 is,
Well, there were two add-on calendars, one with all the,
oh, there it is. Never mind. Got it.
Yeah.
Never mind.
Okay.
2 prior arrests. His first arrest was dismissed.
you got it, Mr. Jenkins?
Yes, I
Okay.
do.
All right. All right, go ahead, Miss Beck.
It's me, Judge.
I'm sorry, Miss Pinto.
That's okay. Yes, Mr. Wiggins was granted a $20,000 bond in November of last year. He has been unable to pay that bond. We are asking for a reduction today.
Does anybody remember Miss
He, as
Wiggins?
stated by pretrial, he has no felony convictions. Only 2 prior arrests, one of which was dismissed. Regarding his Ayala factors, Mr. Wiggins did go to high school until the 12th grade, but he was not able to graduate. He is currently working on, prior to arrest, working on his GED.
Wow.
He is close with
That
his
could be
family.
interesting.
He's lived with them his entire life. Prior to his arrest, he was living with his father, Donald Wiggins,
There we go.
and his mother, Stephanie Wilkes.
Thank
His
you.
family is all here in
feel
Atlanta,
better now,
Judge.
Tanya.
He has strong ties to the community. In addition, Judge, he has had a lot of issues while incarcerated. He's been physically assaulted. He's been extorted.
Thank you.
And this has all happened consistently to him over the past few months. Accordingly, his family is deeply concerned about his safety. And the jail has tried to move him to help, but nothing has helped, Judge. He continues to get attacked. His family is indigent. They cannot afford bond. As stated, he's not at a risk of committing any further felony, or being arrested for any felonies. He has no convictions. The one other arrest, I understand to be a misdemeanor. He's not a flight risk. His entire family is here. He intends to return to court and fight these charges, Judge. He has no history of failing to appear in court. He's not at risk of intimidating any witnesses. He will,
Have you ever had a failure to appear?
or no contact provision is put in place. He does not wish to have any contact with the alleged victim or her family. He's also not a danger to the community. Judge, we are asking for a UJR based on the fact that his family cannot pay bond. And given, his safety issues at the at the jail, he's been stabbed multiple times. And, he's already been deemed eligible for a bond, Judge. We're simply asking for one that would be reasonable for someone in his financial situation.
Okay. What says the state?
Thank you, Judge. Briefly, we request you deny defense counsel's motion. We don't see any facts, circumstances that would warrant a reduction in this case. We believe the bond is appropriate as is. It's $20,000 good bond with the same conditions. Thank you, Judge.
Has there been contact with the victim or victim's family?
I cannot say that at this point. I don't know, and I do apologize to the court. However, with the allegations, obviously it appears to be a minor, and so that causes certainly the state concern in connection with, any potential contact. And the defendant, as you know, stands here, or not stands, but sitting here today, already has a bond. And so we just don't believe anything justifies a reduction in that.
Is the Beecher Road, Ms. Pinto, where on the bond conditions that the other judge did, another judge did this bond, it said must reside at, that's where he will live?
He can reside there, Judge, or he can reside with his parents. The problem is I think the alleged victim is in the same complex as his parents.
Oh, okay, so that may be
So-
why they did that. Okay. Yeah, and it may be harder to stay away. All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with, the name's already on the previous bond order, so, but NL, minor, no further contact with anyone under the age of 18. Stay away from 3540 North Camp Creek Parkway. So we'll do the must reside at 2136 Beecher, Beecher Road in Atlanta, Georgia. You'll have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you provide proof of employment, name of employer, and the location, exact location you'll be working, and a schedule. Third, that doesn't mean you get a job and then leave it after you've shown proof and act like you're going to work, because they do monitor the ankle monitors. That ankle monitor and staying away from there. 259 days. I'll put this name on my list. $15,000.
Yes.
Best of luck to you, sir. You can leave.
Judge, could we, I know he's returning to his GED studying. Could we add a 24-hour exception to something like
Sure.
regarding his GED or education?
Sure, you can work on your GED, sir. You can add that, Miss Rose, as long as you provide proof you're enrolled in class and go into the class, okay? Thank you. Mr. Wiggins, you can leave your booth.
Got it,
Judge, what
Judge.
was that booth amount? What was that bond amount? I'm sorry.
15,000. Because somebody said it at 20, but he's been in 259 days. Yes, Ms.
And
Rose, you got,
Yes, I do. You said 2136 Beecher Road, correct? That's where he must reside.
everything. Yeah, I'm reading off the previous bond order. When I scan you all that, it's this there. Yeah.
Okay, yeah, that's what I was looking at.
Yeah,
Okay.
2136. Yes, ma'am. All right, let's see. Tremaine Jordan. Tremaine Jordan. No Tremaine Jordan yet? Nope, there you are. All right, this is position 1. This may have been on one of the add-ons. This is 22 CP 214076. But what I see here is there's already a bond order for $7,500. Where's Mr. Lane?
That's what I have.
And I didn't see where they had came off of it. Sir, give me a thumbs up or a thumbs down. I mean, do you know if they came off your bond? I see. I just need a thumbs up or a thumbs down. They did come off your bond. Okay. So Mr. Lang's not here. Anybody want to?
Your Honor, I apologize. I am present. I
Okay.
did not see this case on one of the calendars. Can we handle this case next to give me time just to grab the file?
Sure, because he said it looks like Atlantic Bonding may have came off his bond.
Yes, Your Honor. I apologize for the oversight. on
No,
that.
no, that's okay. I mean, we all make, we're good. Thanks. Yeah, we'll come back to you right after I handle this next one. Let Mr. Lang pull his file up, okay? Jose Hernandez.
Yes, Your Honor, and we would waive reading of the charges on that.
Okay, and you need, does he need an interpreter?
No.
Okay. So we got position 23, 22 CP 214450, Jose Hernandez at 118 days without indictment and no bond. Of course, you charged with 2 felonies. Pre-trial.
In regards to Mr. Hernandez, 5 prior arrests, does not appear to have any felonies, 2 arrests for probation violations, 2 misdemeanors, drug-related objects, and DUI. Nothing further.
All right, go ahead, Mr. Anderson.
Thank you, Your Honor. As you said, Mr. Hernandez has been in jail for 118 days, no bond, no preliminary hearing, no indictment. He is 28 years old, currently lives with his partner in Smyrna. His father, sister, brothers, grandparents, basically entire extended family is here in Georgia. He has lived in Georgia since he was 6 years old in the metro area for the past 2 years. I've spoken with his partner a few times. Everyone's been very involved with his case. He would be able to return to that Smyrna address. Prior to his arrest, he worked as a server at the Italiano restaurant at the Battery and would be able to return to work. He has a high school diploma and a trade diploma for medical assistance. Basically he has never left Georgia, aside from a childhood trip to Florida. So he's not a flight risk. He has strong ties to the community. And, without getting again into the details of the case, the warrant on its face is totally void of arguably the most essential element of the charge, which goes to the Lane v. State factors, the apparent probability of conviction, likely sentence as far as those factors are relevant to appearance. Basically, Mr. Hernandez is very eager to get this to trial and get this resolved. I would also note that the pretrial report specifically says he is a release level score of a 1 and specifically recommends him for UJR, which is what we would request.
All right. What says the state?
Thank you, Judge. Obviously, our position is different. We request he denies defense counsel's motion. However, of course, he is entitled to the bond through statute. And though they're merely allegations, they are predatory in nature. And as such, state's requesting $500,000 on count 1, $500,000 on count 2 cash for $1 million with the following conditions. He's banned from Fulton County, that he has no contact with the alleged victim, who was a minor.
That ban from Fulton
No
County,
social media,
that's a gimme.
24-hour curfew, ankle monitor, stay
Guaranteed.
away, and the other terms and conditions the court deems appropriate in this matter. Thank you, Judge.
All right. So I've looked through. I didn't have, do you have the victim's initials? Because I didn't really.
Hold on, let me check the warrant, Your Honor.
Because I looked, of course, I was been working, I could have missed it.
Now, you've, hold on. Let me bring this thing up here. 214.
I didn't know if it was like a alleged sting or
It
Oh,
is.
this is, I contacted this person through Grindr. Hold on.
wait, who just said something?
Your Honor,
No.
maybe
Uh-huh. Okay, that's what it was. Okay, it was you. I was thinking maybe it was somebody else who's on here laying in their bed and I was about to lose my mind. Okay,
Let me
so it
try
was
to-
you, Miss Taylor?
yes, Your Honor.
Okay, so it was. So there's not, it's just anyone under 18.
Yes.
All right. Anything else you want to add, Miss Taylor?
Hey, stay away from internet, social media, everything
Okay.
else.
All right, no drugs unless prescribed, no alcohol, no weapons, no use of a computer. Internet/computer, no use of any of these, I guess, dating or hookup apps. One specific, I think, is Grindr or any other social media dating hookup, whatever apps. No further contact with anyone under the age of 18. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. Keeping in mind these other conditions, as long as you supply the name of your employer, location, schedule, and proof of employment. But you have to comply with those other conditions. So if that doesn't, then you can't do that. And you got to stay out of Fulton County. The only reason you come to Fulton County's court or to see your lawyer. Did you want to respond, Mr. Anderson?
Yes, Your Honor, we would object to a broad ban from Fulton County that is not related to any of the elements of the case. There's actually some case law on that
Oh, here we go. Finally, someone
related to it's Dudley v.
fights
State.
back.
It's Court of Appeals case 230 Georgia App 339. Specifically said total banishment from the county was one of the conditions imposed, and it said such restrictions appear to be totally unrelated to the offense for which the defendant was convicted. This was for a
Oh, that's for a
supersedious bond,
conviction when somebody, yeah.
and therefore unreasonable as a matter of law. So, in this case, I think the protections for pretrial release are even stronger since there's no conviction than they would be in a post-trial situation. So therefore, I would say a blanket ban from Fulton County is unreasonable and unrelated to the case.
I think the nature of the crime and that it occurred in Fulton County is worth banning to protect our citizens and of Fulton County. All right, so I'm gonna do 300,000 on each count, a total of a $600,000 good bond. Best of luck to you, sir.
Chick-fil-A? Please tell me it's not Chick-fil-A too.
Your Honor, I believe, oh, no, sorry.
I think that's it for you. I
Yes,
think that's the
that's-
only case, right, Mr. Anderson? Good to see you again.
I'm
It's been
sorry,
a
yeah,
long
I'm sorry,
time, like
I'm sorry,
30
I was
minutes.
looking at something else. What was the amount? again?
300 per count.
Okay, thank you.
It
Thank
was
you,
like I
Ira.
saw you 20 minutes ago.
Yeah, pretty much. All right, thank you, Your Honor.
DeAndre Mobley.
Your Honor, I am prepared on Mr. Jordan whenever. the court
Okay.
is.
All right. So, Mr. Hernandez, you can leave the booth. So we got Tremaine Jordan. Go back to number 1. 22 CP 214076, 116 days without indictment, criminal damage to property the second degree. There was a $7,500 good bond that I said previously, November the 19th, but they came off that bond. Rah.
In regards to Mr. Jordan, 17 prior arrests, 2 FTAs, 2 misdemeanors, 1 being a simple battery in 2021. First offender on the aggravated assault in the 2015 purchase, manufacture, and sale. Nothing further.
All right. Go ahead, Mr. Lang.
Yes, Your Honor. To start, I'm a little confused as to why we find ourselves in this position. I did look back at the previous jailing and this jailing. I did find the documentation filed by Alpha Bonding stating that they were surrendering this bond. There does not appear to be any reason given. So I am unsure entirely why this bond was even surrendered in the first place. However, that's not what we're here to talk about. We're here to talk about the new bond. Mr. Jordan is 34 years old. He is a lifelong resident of Georgia with his entire family living here as well. Lives at the good address on record with his aunt and brother. He has 2 children, age 14 and 16, whom he sees every weekend and provides for in every way he is able to. At the time of his arrest, he was working as a forklift driver. He's been doing that for the last 2 years. He was initially only detained on this case for 4 days before making the previous bond. However, now that that bond had been surrendered, he's been sitting in custody for 116 days, waiting for the opportunity to get a new bond in this case. Based on the nature of the offense in this case, it is a single count of criminal damage to property. I would ask the court to consider actually setting a lower bond than was initially set and setting $5,000, since he's now back in custody and having to attempt to pay this bond a second time. Otherwise, based on the fact that we have no information as to why the bond was initially surrendered, I would ask the court just to reinstate the previously existing bond of $7,500 good.
The world frightens and confuses me.
I'm leaving the court's discretion in connection with the bond. I'm not certain as to why the bond was,
Yeah, and I didn't know
surrendered.
if it had been, or that's why I couldn't really tell. And sometimes there's a reason on there.
Right.
So we will do no further contact with Dayshundra, Dayshundra, middle name Ronika, Ronnika, last name Wilson, Wilson. Stay away from 2500 Center Street in Atlanta, Georgia, at $5,000 good bond. Best of luck to you, sir.
Thank you, Judge.
Thank you. You lay the booth, sir. So now we got DeAndre Mobley. DeAndre. There you go. Mr. Cho, position 14, Bostic 22 CP 212477. 193 days without indictment. As of December the 5th, there is a $50,000 good bond. We've got aggravated assault vehicle into person, willful obstruction of law enforcement officer, misdemeanor, fleeing, attempting to elude, driving, hit and run. Reckless driving, no insurance, and suspended registration. Pre-trial. Sir, 5 South, move forward. What are you doing? Ordering food? Snacks? Checking your messages? Yeah, okay. No, you can do that after this. Bostic, pre-trial.
In regards to Mr. Mobley, 23 prior arrests, 5 misdemeanors, 4 arrests for probation violation, 1 FTA, 4 felonies. Oh, I think that more than that. He has prior firearm by convicted felon, entering auto, theft by shoplifting, firearm by convicted felon, criminal attempt at a felony, firearm by convicted felon, aggravated assault, on probation from 2018, out of Clayton, 3 years. Confinement, 4 years probation. Nothing further.
All right, go ahead, Mr. Cho. Oh, you're on mute.
Thank you, Your
Yeah,
Honor.
Go ahead, yeah.
Judge, before you use Mr. Mobley, his bond, I believe, is approximately $50,000 right now. This is a case where he has been in custody for some time, 193 days. The probable cause hearing was done in, I think, December. So there does appear to be some delays in the processing of this case. The last bond was heard on December 5th, 2022, and in between that time, there have been numerous changes in circumstances for Mr. Mobley while he's been at the 901 Rice Street Jail, including being injured, beaten, having his bones broken, apparently, and threatened by other people at said jail. Veronica Barnwell is someone who loves Mr. Mobley very much, and his family as well have been trying to scrap together the funds for a bond, but it is out of the family and friends' reach. And so he has ties to the community. There is nothing further the defense can do at this point until the case is indicted. There are, it's my understanding, 2 outstanding holds currently showing, one for Fairburn and one for Clayton County. If the court's inclined, we'd ask the court to consider a UJR to the hold. If the court is not so inclined, we're asking the court to consider a reduction in this case. We'd ask the court to consider a reduction in half. Nothing further.
All right, what says the state?
Very briefly, Judge, we believe that the bond, as it currently sets, is appropriate with the defendant's criminal history and likelihood to catch another offense. The fact that he's on probation with these current charges, that merely allegations, of course, but he's just not an appropriate candidate for a reduction at this time, Judge. Thank you.
All right.
Ooh.
This is another judge that set this, so let's see.
I see
would it
that
be
now.
No drugs unless prescribed, no alcohol, no weapons. Mr. Cho, this other judge said must reside at Kingswood Circle. Is that still where you'll be living, sir? I need a thumbs up or a thumbs down. There you go. Okay. So there's no problem with that. So must reside at 5254 Kingswood Circle in Atlanta, 30349. Got a ankle monitor paid for by the
Probably-
county with a
probably in Fulton
24-hour
County.
curfew, court, lawyer, medical appointments, employment. As long as you supply the name of your employer, place of employment, schedule, the exact location you will be working. You have to supply that to Mr. Cho and the ankle monitoring company, sir. If you don't, that'll be a violation of your bond and they will revoke it. And also it says no driving. Yeah, she put no driving. No, let's see, stay away from 840 Sonoya Road. And like I said, the ankle monitor will be paid for by the county. No drugs, no alcohol, no weapons. So I've got, let's see, 193 days. 15,000. Count 1, 500. Count 2. 8,000, count 3. 8,000, count 4. Reckless, 3,000. 1,000.
Interesting.
And 1,000.
And thank you.
$15,500. $8,000. 8,000. 3,000. 1,000. 1,000. Got that, Miss Rowe?
Yes, Judge, I have it. Thank you.
All right. Best of luck to you. I added conditions, so when I do, I give them a little, drop it down. So, all right. Best of luck to you, sir. You can leave the booth. Mr. Cho will call you later. Russell Warner. All right. Miss Pinto. Disposition 122 CP 214551. 112 days without indictment. Possession of firearm by a convicted felon. Criminal trespass, damage to property, giving false information. Law enforcement officer. No bond as of December the 9th. Free trial.
Who did you say?
Russell Warner. I was counting on you to make it go fast tonight, Boston.
Judge, in regards to Mr. Warner, number 46. 46 prior arrests, I mean. Felony, he has 9, FTA 1. He's on 3 probation, 17 SC 154250, arson in the second, 2 counts, arson in the first, 1 count criminal damage to property sentence in 2018, 10 years, 19 SC 168325, aggravated assault, family violence, aggravated assault with a deadly weapon, firearm during, firearm by, 19 SC 168693, aggravated assault with a deadly weapon, firearm during, firearm by, Both of those cases was sentenced on the same day, 7/31/20, 1 year confinement, 4 years probation. Nothing further.
All right, Ms. Pinto.
Thank you, Judge. Yes, Mr. Warner has been incarcerated 112 days with no bond, thus he is entitled to a bond. He is 50 years old. If released from jail, he would reside on Browning Street. That's a rooming house, and he spoke with them just a couple days ago, and they confirmed that his room is still available. I'm not sure if that's, so I'll need to file a change of address, Judge, to make sure that he receives his notices there. He is native to Atlanta. He's lived here his entire life. He does have 3 children, ages 16, 16, and 21 years old. He does have his GED, and in addition, he did some mechanics training at Atlanta Area Technical College. He was working at the time of his arrest at Solutions A&E. They do repairs on the guardrails on expressways. They have a contract with DOT. So he's worked there for 3 years. He is confident he can return to that job. He spoke with them since arrest, and he is confident he can return. He does have family in the area, his mother, his sister, his brother. Judge, we are asking for a reasonable bond for Mr. Warner today. He is indigent, so he cannot afford much. We would ask for a UJR on the 2 misdemeanors and a $5,000 bond on the felony.
All right. What says the state? And I see that the alleged victim is on here. Ms. Henderson.
Yes, Judge. Being that this defendant is entitled to a bond, we want one that's appropriate. And so obviously no contact with the victim in this case. In addition, $20,000 on the possession of firearm by convicted felon, $1,000 on the remaining misdemeanors, cash. Stay away, 24-hour ankle monitor, 24-hour curfew, excuse me, Your Honor. Ankle monitor, stay away, and it appears that he is a repeat offender, which obviously with his 46 cycles, felonies and misdemeanors in these matters. And we'll certainly put this on our list for expedited charging.
Ms. Henderson, would you like to address the court, or are you just here to see?
I'm just here.
Okay, so do you have an opinion?
I dropped the charges.
Well, no, that's not an opinion that we accept.
Oh.
But you're just here. I got you, because we don't do that. This is bond. You want to do that?
Oh.
You handle it somewhere else. But I appreciate you. Thank you. All right,
Judge, can we ask how she feels about bond?
all right, Ms. Henderson, how do you feel about bond? But you got Ms. Henderson.
Oh, you can
Hold on, Ms. Henderson. So you have to turn your camera on.
come on.
Yes, ma'am. You can raise
Oh,
your.
I want
hold
them to have a bond.
on. You raise your right hand for me.
Oh,
Do you swear a firm testimony about to give truth, whole truth, nothing but the truth?
yes, I do.
Okay, go ahead, Ms. Henderson. What is your, you want him to have a bond? Okay.
I want them to have a bond.
Okay. Anything else you want to ask Ms. Pinto?
Yes, Judge. Ms. Henderson, how do you feel about having contact with Mr. Warner?
Oh, it's fine. He can call me anytime.
Are you in fear of him in any way?
No,
She's a regular blondie.
I'm his mother.
You're his mother.
Right.
Yes.
Well, you're the victim. He damaged stuff in your car. You had to call the police. So are you wanting contact? No violent contact?
No violent contact, but he can call me.
We'd be fine with no violent contact, Judge.
All right, Ms. Rowe, if you put on there that the alleged victim appeared, that'd be fantastic.
I will.
With the 5 North, booth 4, come on in here. Set it back down. All right, so we got no drugs, no alcohol, no weapons. You can only go back to 590 Cascade Avenue if you are invited. only if you're invited by your mother. You understand that? All right. No further violent contact with Samia Henderson. You still have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, place of employment, location you'll be working, and a schedule. You have to supply that on a weekly basis or however you're given your assignments. And also, sir, you must provide the address where you're going to be living. And if Ms. Pinto's getting you in some sort of program, you can leave to participate in any type of program that she gets you into. 15,000, 1,000, 1,000. Best of luck to you, sir. You can leave the booth. All right, Kaylin Giles. Kaylin Giles. All right. Well, it looks like you were stretching, not waving. All right, position 2. 22 CP 211179. 240 days without indictment. So we got possession of firearm by a convicted felon, giving a false name, address, date of birth to law enforcement officer, and theft by receiving stolen property. Rah.
Position 2 on a add-on calendar.
Yes,
Yes, sir.
Mr. Jenkins.
Kaylin Giles. Thank you, guys.
It's the one with 6.
Yeah.
Mr. Giles, 9 prior arrests, 3 misdemeanors, couple of FTAs and first offenders. First offender on an entering auto, first offender on a burglary. Currently on probation, entering auto, 5 counts, sentenced in 2018, July of 2018. 1 year confinement, 4 years probation. A felony fleeing and eluding in 2019, and then on probation from 2021 for criminal use of an item with an alter ID firearm out of Cherokee for 10 years. Nothing further.
All right. Go ahead, Mr. Cazzoli.
Thank you, Your Honor. Before proceeding on bond, I just want to make sure that that we have the right charges listed out. It's my understanding that
So the robbery by sudden snatching and possession of firearm or knife during the commission of a felony.
Yes, Your Honor, was I believe the case with the possession of a firearm was still included on the calendar, but it's not on Odyssey, I believe. So everything should be correct.
Well, the possession of firearm by a convicted felon. Let's see. The only 2 I have that were dismissed was robbery by sudden snatching and possession of firearm during the commission of an attempt to commit certain felonies.
That's what I see as well, Your Honor.
There's still possession of firearm by a convicted felon.
Okay, understood, Your Honor.
Yeah.
Mr. Giles is 23 years old. He's had a birthday since his arrest. He has a good address still at 746 Mayland Avenue, Atlanta, Georgia, 30310, where he lives with his father. He lived there 5 years before his arrest in August. He's a lifelong Atlanta resident. His mother, his grandmother, his children, and his aunt all live in Atlanta as well. Your Honor, he was working at Sky Cylinder, a warehouse, doing loading for 2 years before his arrest. His bond is currently set at $10,500, Your Honor. He had his preliminary hearing back in December, and there has been no indictment. So we are asking for a reduction to $5,000 so that he might qualify for the bail project.
What says the state?
Briefly, Judge, we request you deny defense counsel's motion in this matter. We believe the bond is appropriate as stated with his criminal history. And so that's all, Judge. Thank you.
So, Mr. Gazzoli, like on the other ones, some judges put they must reside at. Is he still allowed to reside at the Maryland Avenue?
Yes, Your Honor. I believe when, the most up-to-date information I have, I believe, is from January. Mr. Giles, if you can put your thumb up, sir, are you still able to stay with your father at that address?
Okay.
Okay. Thank you, sir.
Just want to make sure. All right. I don't want to put it on there, then he ends up jamming him up because he can't live there. All right. So no drugs unless prescribed, no alcohol, no weapons. Stay away from 680 Lee Street Northwest. Stay away from all MARTA property, sir. Bus stops, train stations, anything that's got MARTA on it. If you're walking down the street, you walk past the bus stop, you cannot sit down on that bench and tie your shoe. That would be a violation of your bond condition, to sit down on a bench with MARTA at a MARTA bus stop and tie your shoe. Walk past that, sit down on another curb and tie your shoe. No further contact with Charlottine, Charlottine Banks, Banks. And Renee, Renay Banks. And no further stay away from no further contact with your co-defendants. Marcus Brookins, Brookins, Jamar Cullins, Cullins, and Simeon Glover, Simeon Glover, Meon Glover. An ankle monitor paid for by the county. You have a 24-hour curfew, court, medical emergencies, lawyers' appointments, medical appointments, and employment. As long as you supply the name of your employer, place of employment, the exact location you'll be working as scheduled. You have to supply that to your lawyer and to the ankle monitoring company. It must reside at 746 Maryland Avenue Southwest. If that, for some reason, that address isn't available, sir, you have to supply your address where you will be living upon bonding out. So if it's that one, you need to confirm it. And I think I said no drugs, no alcohol, no weapons already. All right, so let's see. I added a few things. 5,000, 1,000, 1,000. Best of luck to you, sir.
Just water.
And I'll put this
Unfortunately.
on my email this evening. Got my
Thank you,
stack
Adam.
already going here. All right, so yeah, we got Travius Duggan. Mr. Duggan. There you go, Mr. Duggan, Mr. Lane.
Yes, Your Honor, Mr.
All right,
Dugan.
it's position 422 CP 211441. Travius Jamal Duggan, 230 days without indictment, aggravated assault, willful obstruction, felony, carrying a weapon within school safety zones at school functions or school property, theft by shoplifting, misdemeanor, disrupting public school, possession of firearm or knife during the commission of felony. Great trial.
In regards to Mr. Duggan, 19 prior arrests, 7 misdemeanors, 2 arrests for probation violations, 2 FTAs, arrest in North Carolina and a whole felonies in Georgia, controls, well, no, it was the first offender in 04 and a DUI in 2015. Nothing further.
All right, go ahead, Mr. Lang.
Yes, Your Honor. Mr. Dugan is 39 years old. He was 38 at the time of his arrest. He celebrated his 39th birthday in Fulton County custody.
Happy
Born
birthday.
and raised here in Georgia, has lived at the address on his booking report with his aunt for several years. That is a family home that has been in his family as long as he's been alive. He had a child born on December 27th of last year. His first child, his son Jason, whom he has not even been able to see a photograph of, let alone meet. He graduated from high school in 2002, graduated from Clarkston High School. He then went to the Brunswick Job Corps, where he got a certification in both residential and commercial painting and welding. He has those certifications as well as a forklift operator certification and his CDL.
I'm surprised we don't have a
working
verdict
for
yet.
a Kroger distribution center for 6 years as a
Really am.
forklift driver there. He has been in contact with them while he's been in custody and has been told that no matter how long he is in custody, that job will be waiting for him. They will hold a spot for him so that he is able to return to work upon his release. Listening to his history, also looking at the nature of this case, Your Honor, Mr. Dugan has been in custody for 230 days on this case. He had his preliminary hearing back on November 30th of 2022. That was actually the second set date for that preliminary hearing. The officer didn't even bother showing up the first time, then showed up 3 hours late the second time. His mother, who should be on the call today, has been present for every single court hearing he has had in this case. He has extensive family ties and extensive family support in this matter. The state could have indicted this case any day after November 30th and has not. Based on the information presented, I am asking the court for a very low bond. I have spoken with Mr. Dugan and his family. The maximum bond he can afford is a $10,000 bond. So I am asking the court for a $10,000 bond. $2,500 on the ag assault, UJRs on the obstruction, theft, and disrupting school, $2,500 on the carrying weapon, and $5,000 on the firearm during. I understand that may sound low, Your Honor. He has been in custody for 230 days, 4 months past his preliminary hearing, and there has been no movement on this case. It is unjust and unfair to continue to hold Mr. Dugan in custody when the state does not appear to be moving on this case in any way, shape, or form.
Okay. Let's see. Hold on one second. 1 North, booth 4. You okay? Are you okay? Okay. All right, just didn't know if you weren't feeling well. All right, what says the state?
Thank you, Judge. We request that you deny defense counsel's motion in this case for bond reduction. He has, I believe, 30,000 straight bond, and with his prior criminal history and where his status is, we believe the bond is appropriate. Thank you, Judge.
Mr. Lang's not surprised. I'm gonna add a few conditions. Mr. Duggan, my sincere congratulations on your first child. However, no drugs, no alcohol, no weapons. He gonna live in Decatur? Still gonna live in Decatur,
Yes,
sir?
Yes,
Oh,
Your Honor, the Decatur.
Okay, he's still gonna live in Decatur. Can you hear now, Mr. Duggan? Okay. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 111 Boulevard Northeast, Hope Hill Elementary School, and any schools in Fulton County, since you live in Decatur. So you're gonna stay out of Fulton County unless you're here for court or to see your lawyer. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. No further contact with DULALMRIDAH.
Your Honor, for the stay out of Fulton County, can I ask that employment be an exception to that as well? I believe the warehouse he works at is within the Fulton County border.
Okay, employment, that's fine. Employment only, as long as he supplies his schedule and that location he's gonna be working every time. All right. So we got. You got 9,000, 5,000, 4,000, $100 on the misdemeanor, and then 1,000 and 8,000. 9,000, 5,000, 4,000, $100, 1,000 and 8,000. You got that, Miss Rowe?
Yes, Judge.
All
Thank
right,
you.
there you go. Best of luck to you, sir. Did you hear that? You can leave the booth. I don't know who's really. Were you able to hear, sir?
Mr. Dugan, she said a $27,000 bond. I'm going to talk to your family and figure out what we do from here.
Judge, you want me to unmute it?
Well, you go over to, if you want to, sir, go over to booth 1 real quick. Go next door. I don't know if he could hear in there. Was right next to each other. Where'd he go? All right, if he comes back, we'll tell him. All right. Okay, there you go. So Laterio Woods.
Your Honor, that concludes my business before you. May I be excused?
Yes, sir. All right. Have a good evening.
You too.
22C is position 5, 22CP 211788. I think this one may be on the add-on. Who's covering this for Miss Bray this evening? Miss
I'm
Pinto.
Judge. What was the client's name?
Laterio Woods. It's 22CP 211788. 218 days without indictment, possession of a firearm or knife during the commission of or attempt to commit certain felonies, theft by receiving stolen property, felony, possession of marijuana less than an ounce. Pre-trial.
Woods, multi-state offender, 3 in Tennessee, 2 in Mississippi, 2 in Georgia. In Mississippi, he has a 2020 theft by receiving stolen property, false information. Tennessee, there's a hold for larceny. And then in Dorville, there's a hold for carjacking. Nothing further.
All right. Go ahead, Miss Pinto.
Thank you, Judge. Sorry, there they are. Mr. Woods, is 21 years old.
Thanks for telling me.
His address
I'm monitoring closely
is
for when they
actually
come
in
back.
Memphis, Tennessee, Judge. That's where he resides with his mother. And that's where he would need to go if released on bond. He did get his GED in 2020. And he has been deemed eligible for a bond. He was granted a $10,500 bond. And we are asking for a reduction. He has, of course, not been able to pay that bond. It's too high for him and his family. Sorry, Judge. And so we would ask for a reduction.
For the defendant all
by
day
half.
long. I think that from watching the trial,
Go ahead, Mr. Jenkins.
and
Thank
also
you. Very
good,
briefly, Judge. We
really
request
quick.
that you deny defense counsel's motion at this time. We believe the defendant's current $10,500 bond is appropriate and with the same conditions and any other adjustments the court believes in its discretion is appropriate.
All right. So I'm going to add some couple of conditions here. So
Absolutely.
no drugs unless prescribed, no alcohol, no weapons, no further contact with Lance Browder, Browder. Also stay away from 6120 Peachtree Dunwoody Road. He's going to be living in Memphis.
I didn't hear what you said, Judge.
Yeah, he's going to be living in Memphis, Mr. Jenkins. Is that where he's going to be living?
He's got a hold out of, he's got a Doraville, pending charges in Doraville for armed robbery.
I was carjacking. So he gets released from his hold and goes and handles that. Is he going to go back to Memphis, Miss Pinto?
Well, the only hold I see is for Tennessee. So he would be transferred to Tennessee, presumably.
Boston.
On his GCIC, there's a hold in Doraville for carjacking.
That's not on the jailing side.
Oh, and GCIC. Oh, yeah. Oh, for a warrant. So any other restrictions?
When you run the GCIC, if they have holds, it pops up who has warrants, whether or not they were extradited, etc.
Okay, so, well, ultimately, when he's released from custody, his residence is Memphis, so that's where he would go.
All right. So anything else you want to add, Mr. Jenkins?
If he were, I would like to ban him from every state in the every state. What am I saying? Every county in the state of Georgia, except for possibly Clayton and court appearances here in Fulton County. Clayton would be before the airport would be added if there aren't a proper hold from Doraville regarding this hijacking motor vehicle case.
So
Judge, I don't see how a statewide ban would be relevant at all to this.
Oh,
case
no.
that's on the calendar.
There's a couple of counties he can go to.
I think what concerns him is most of the other stuff, but we'll do. And do you want an ankle monitor? I won't prove
Just
he's going
stay
to
in
come
Clayton
back
County.
here.
This is a whole new level.
This case is my concern. If he's going to be in Memphis.
Well, Judge, I mean, the bond is the assurance that he would come back. I don't think that, as far as I know, the ankle monitor company cannot monitor him if he's living outside.
Yeah, they do. They can.
That I did know. Thank you, Judge.
Yeah, they can.
If they can monitor him in Memphis with conditions, we can do. I would approve of that. I request that, Judge. I didn't know that myself.
The other part of if there's holds out there, even though he has a presumption, it makes me kind of concerned.
Sure.
So I'm adding, since I'm adding some, so ankle monitor, 24-hour curfew, court lawyer, medical, employment. As long as you supply the name of your employer, place of employment, schedule, and the exact location you'll be working. The only reason you should come back to Georgia is for court or to
This is
see your
18
lawyer.
minutes. Counting down.
State of Fulton County. So for
On
court
law
or
and
to see your
crime.
lawyer.
For what it's worth.
So since I added some, I'll make it 4, 3. Wait a minute. Somebody put and 4,000, 3,000, and 100 on the misdemeanor marijuana. Best of luck to you, sir.
Thank you, Judge.
Yes, ma'am. Frederick Woodruff. All right. Position 12. Wait, I think that's one I need to. Yep, I'll put that one in my email too. Position 12, 22 CP 214724. Frederick Woodruff, 116 days without indictment. So we got. And if we can please put this on the record that I am not the one that set these bonds on these gang charges.
Okay.
116 days without indictment, possession of firearm by a convicted felon, unlawful for a person to commit offenses with intent to earn, obtain, maintain increased status within a gang, unlawful for a person employed by associated criminal street gangs to conduct or participate in criminal street gang activity. Somebody else said 10,000 apiece on that, but there's no bond on possession of firearm by a convicted felon. Pre-trial.
I'm sorry, Judge, which is this?
Frederick Woodruff, position 12.
Okay, thank you.
Yes, ma'am.
Woodruff,
Yes,
12
ma'am.
prior arrests, PTI on a robbery and aggravated assault, simple battery in 2017, FTA in 2019, to arrest for probation violation. Open case 22 CP 209964, theft by receiving firearm by and street gang activity. Nothing further.
All right. Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Woodruff has been incarcerated 106 days. He is no bonded on one of his charges, thus he is eligible for a bond. I would ask the court to leave the bonds that exist as they are. Regarding his Ayala factors, he's 24 years old. He's resided in Georgia his entire life. He does have a good address on Desert Drive. That is where he'll receive his court notices and where he lives with his mother. He does have one child, who at the time of his arrest was 9 months old, is probably just hit its first birthday, Judge. He did graduate high school in 2017. And he was working as a package handler at a warehouse. He'd been there for over a year. So he has very strong ties to the community. We are asking for a reasonable bond for him. Of course, as stated, he is entitled to a bond on that possession of firearm by convicted felon. I would ask for that to be 10,000 and the other charges remain the same.
All right. There you go. There's Mr. Bridges. Go ahead, Mr. Bridges. What say you about Frederick Woodruff?
Your Honor, the interesting thing is this is initially he was arrested on the gun charge. The court gave him no bond on the initial appearance, and they said significant likelihood to reoffend, risk of failing to appear, and danger to community. I think that's based on his criminal record. Then we came along and one of your colleagues gave him $10,000 bond on each of the gang charges, and once again, no bond on the gun charge. Once again, citing that he has significant likelihood to reoffend, risk of failure to appear, and danger to community. Your Honor, based on that, I'd actually ask that the gang charges bond be raised to at least $100,000 on each, and then $50,000 on the gun charge.
All right. And one of the so it's Goodfellas, though, right?
Goodfellas, Your Honor, and he was actually in the Goodfellas stronghold area when he actually had the gun in his possession, and his conviction was just from 2018. I think he was still on probation for that. That was out of Cobb County.
And what area of the town is the Goodfellas stronghold?
Jones, I think it's Jonesboro Road, Your Honor. Joseph E. Boone Road, Your Honor. The specific address was 1575 Joseph E. Boone address.
What do they call that area of town? Is what I was trying to think of.
That I don't know, Your Honor.
Yeah, it's not some. Okay, can't think of it. All right, no drugs, no alcohol, no weapons, no replicas of weapons. Stay away from 1575 Joseph E. Boone Boulevard Northwest. You gotta have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and medical. No further contact with anyone that's a member, pledging to be a member, trying to be a member, thinking about being a member, affiliated with Goodfellas or any other gangs, not just Goodfellas in particular. Let's see. And if your address changes, you have to keep your address up to date. 50,000 count one, 100,000 count two, 100,000 count three. Best of luck to you, sir.
Your Honor, I'm sorry, I didn't hear you mention social media and.
Oh, yeah, yes, sorry, yep, sorry about, yeah. I said no replicas of weapons, but no social media.
I said 12.
Yeah, I did say no replicas of weapons, but I didn't say no social media.
Okay, thank you, Your Honor.
Best of luck to you, sir.
Judge, we got 50, 100, 100.
50,000, 100,000, 100,000. That's it.
Okay, great.
Thank you. All right. Javon Anderson, Mr. Anderson. There we go. All right, Ms. Pinto, we got 22 CP 211056. 246 days without indictment. There is a $1 million good bond on aggravated assault, aggravated assault, aggravated assault, aggravated assault, aggravated assault. And then instead of me trying to say it all these times, unlawful for a person to be employed by, associated with criminal street gang to conduct or participate in criminal street gang activity. Times 1, 2, 3, 4, 5. 5 counts of that. Preach. Rah.
What, I apologize.
We've
This
got
is
gang
Javon
enforcement.
Anderson, position
Okay.
3.
On the
So
main calendar.
Bridges has this one, okay.
Right.
Yes, Ms. Jenkins, I'm handling this.
Thank you.
3 prior arrests, did not appear to have any felonies. Open case 20, misdemeanor 22 CR 005120Y. Didn't write down the charge. Nothing further.
All right. Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Anderson, as stated, has been incarcerated 246 days. While he has a bond, it's functionally no bond at $1 million. He is indigent, Judge. He cannot afford that bond. He's been deemed eligible for a bond, so we're simply asking for a reduction to a bond that is reflective of his financial circumstances as required by Georgia law. We do have a good address for him on Riverdale Road. He is at the time of his arrest, he was working on getting his GED. He does have 3 children, ages 6, 3, and then he had one on the way at the time of his arrest. I'm not sure if the child's been born yet or not, Judge. As stated, we are asking for a reduction. According to pretrial, he's only been arrested 3 times in his life. He has no felony convictions. He's not likely to commit any felonies if released on bond. He's never convicted or committed a felony, Judge. He's never been found guilty of anything. He does have one open case that's a misdemeanor case. I understand the allegations, of course, are serious, but the purpose of bond is to prevent punishment before conviction. And we would ask that the bond be reduced to something reasonable, I would say 10,000. Judge, I'm trying to find the list. 10,000 each count.
All right. What says the state?
Your Honor, if you recall this case, you're the actual one who set the $1 million bond, and you do recall that there were 6 innocent people that were shot by the defendant. The defendant has not improved his behavior since he's been incarcerated. We have 4 incidents report from the jail on him. In addition, they have him at a high risk due to his disruptive behavior. Your Honor, I would ask that the bond remain the same. I think the judge, Your Honor, made the right decision based on his danger to the community and propensity to commit more crimes.
All right, let's see. I think the only thing I may have left off on here is no drugs, no alcohol, no weapons, no replicas of weapons.
Judge, I'm sorry, can I just respond? I mean, some of these reports they're not due to any kind of violence in the jail. They're due to concern for Mr. Anderson and putting him on suicide watch. So in no way should that be held against him.
Going to respond, Mr. Bridges?
Yeah, the specific that the officer uses is a disruptive behavior. Whether that's a mental, they don't say mental, they say disruptive behavior.
All right. Yeah, no drugs, no alcohol, no weapons, no replicas of weapons. No further contact with the Carrion, DEKARRION, Carmichael, CARMICHEAL, Ivory Davis, CC, initial CE, last name McLean, MCCLEAN, Spiritual Mayo, MAYO, Denizia, DANNIEZZIA Clark. I remember last time his address on Riverdale Road's in Clayton County, right, sir?
Balake.
All right. So stay out of Fulton County except for court and attorney visits. Stay away from 6545 Woodford Road in Atlanta, Georgia. No social media, no contact with any alleged co-defendants, no contact with any gang members, affiliates, or somebody who wants to be a gang member, pledging of rolling, ROLLING, Crips, or any other gang. No alcohol, drugs without a prescription.
Hey, Ron.
And no weapons. 24-hour house arrest. And this one did before, so he was working on his GED. Some court, legal appointments, and medical. Must attend school virtually and comply with the rules and regulations. Let's see. What's the stronghold of the Rolling Crips?
That I don't know offhand, Your Honor.
And I think before I didn't name the co-defendants because I didn't have the names of co-defendants.
And we still don't, we're still investigating, Your Honor. We haven't, we're
Okay.
still working on that.
All right. So, been 246 days on indictment. How close is this to coming to being indicted?
Yeah, we still have work to do on this. Like I said, we have six individuals. We have one young lady was shot in the back. So we're still waiting on them to recover so we can actually get our full investigation completed, Your Honor.
All right. Unless I added anything to those bond conditions, I'm going to deny the motion to modify bond. Best of luck to you, sir.
Thank you, Your Honor. That concludes my business. May I be excused?
Yes, sir. Thank you.
All right, let's go over there. Hello, hello.
They want to.
She wants to be here for the jury. Are we not letting the press in, or what's the purpose of this moment?
I assumed everybody was already in. You can go ahead and let them in.
Chris Palmer's just explaining some things.
Oh, he's just going through the guidelines? Okay. Thank you. And just to verify with the court TV and with the AP reporter, or the AP photographer, if you could listen to me for just a minute. No, I mean, I know this goes without saying, but no pictures of the jury.
Yes. Understood, Your Honor.
Thank you.
So no objection to bringing in the audience if you want.
And
They're not coming in. They're just Chris Palmer's.
They're just being briefed right now. Jody? Okay, okay.
Received international attention.
International attention.
I think we've got everyone in here that wants to come in. If you could be seated, and I'd like to just say a few things before we call the jury in. There is a verdict in the case. I think you've all been told that. Before the jury enters, I just want to say a few things that I say in every case. The court appreciates that this has been a long and difficult trial for the parties and their counsel, and that emotions may be running high. The court reminds everyone that there should be no outward reaction when the verdict is read, and that these proceedings are not over until the court has been adjourned.
No goats?
Most importantly, and regardless of the verdict, the jury has sacrificed more than 8 days of their time to serve, and they are entitled to be shown the same courtesy and respect that they have been shown throughout these proceedings. I want to remind the people that are all here that there are strict orders that are in place concerning the use of phones, cameras, recording devices, unless you've been approved, and there are only 2 people in here that have been approved for capturing anything by video, by audio, or by still, you should not use your cell phone or any other device that might capture those things. Thank you. Ready for the jury? And I have been impressed with how well everyone has been throughout this proceeding, so thank you all. For those that are arriving late, there's no use of any recording devices at all.
Oh, yeah. We don't care here at Let's Talk with Mike. We'll hit the goat and the pickle. And I'll grunt. I mean, might even say, knee. For my man, that a knee. Who knows?
Thank you. For the record, the jury is now in the courtroom and the parties are present with their attorneys. Would the foreperson that the jury has selected please stand and state your number?
Number 19.
Thank you. Has the jury reached a verdict?
We have.
Will you please hand it to the bailiff, and the bailiff will bring it to me? Thank you. You may be seated. Thank you. We'll now have the clerk read the verdict.
Okay.
Was Gwyneth Paltrow at fault? No. Was Gwyneth Paltrow's fault
Yeah.
a cause of Terry Sanderson's harm? Oh, no, skip that.
There's just no response there.
Okay. Was Terry Sanderson at fault? Yes. Was Terry Sanderson's fault a cause Gwyneth Paltrow's? Did Terry Sanderson's fault cause Gwyneth Paltrow's harm? Yes. Comparative fault. What percent of the fault do you assign to Terry Sanderson? 100%. Damages. What amount fairly compensates Gwyneth Paltrow for economic damages? $1. Signed March 30th, 2023.
Thank you. So to juror number 19, the foreperson, is this your verdict?
Yes, sir.
Thank you. And the attorneys have asked that I poll the jury, and so I need to ask each one of you if this is your verdict. This is not an unusual thing to happen. It happens quite often. So number 16, is this your verdict?
Yes, Your Honor.
Thank you. Number 11, is this your verdict?
Yes, Your Honor.
Number 8, is this your verdict?
Yes, Your Honor.
Number 2, is this your verdict?
Yes, Your Honor.
I've already covered number 19. Number 28, is this your verdict?
Yes, Your Honor.
Number 29, is this your verdict?
Yes, Your Honor.
And number 32, is this your verdict?
Yes, Your Honor.
Thank you. So to the attorneys, is there anything further before I discharge the jury?
Nothing for the plaintiff. No, thank you, Your Honor.
Okay,
Thank you to the jury.
let me just read you the last jury instruction. Ladies and gentlemen of the jury, this trial is finished. Thank you for your service. The American system of justice relies on your time and your sound judgment, and you have been generous with both. You served justice by your fair and impartial decision. I hope you found the experience rewarding. You may now talk about this case with anyone you like. You may be contacted by the press or by the lawyers. You do not have to talk to them or with anyone else, but you may. The choice is entirely yours. I turn now to the lawyers and to the press and ask them to honor your wishes if you say that you do not want to talk about the case. If you do decide to talk about the case, please respect the privacy of your fellow jurors. The confidences that they may have shared with you while deliberating are not yours to share with others. Again, thank you for your service. You may now retire. And if everybody else would please remain here, we've got some things to do.
All rise for the jury.
Like what? So yes, if you have a favorable verdict, you may be entitled to fees and costs.
May be seated.
Includes filing fees.
So I've got a few things I'm going to do with the parties, and then I'm going to ask everyone who's still in the courtroom at that point to remain seated while the parties leave. So anyone who wants to be outside when the parties leave, please do that now. So Mr. Owens, I'm looking to you to prepare a judgment on the jury verdict.
Perfect.
Will you do that?
Yes.
Okay. Mr. Sykes, is there anything further for the court before the court adjourns?
No, my client just wants to say thank you to Your Honor for the effort you made to. Okay.
Thank you. Mr. Owens, is there anything further from the defense before the court adjourns?
No, thank you, Judge, and to all your staff and the bailiffs.
Let me just comment that I appreciate the professionalism that all the attorneys have shown and the parties, so thank you.
Oh, good
This
Lord.
court is now adjourned. Thank
Could've
you.
let my client slip out before.
Yes, everyone remain seated while the parties leave.
I'm going to make a quick statement. Ms. Paltrow is not going to be making a statement today.
So you can make the statement outside, Mr. Owens.
I will do that.
Yeah, please. Go tell it to the press. They'll listen to you today. It's your big moment.
Right, we're now adjourned. Thank you.
Well, there you have it. Another one in the books. I told you I could see it all day long. When was it? It wasn't yesterday because I didn't stream, but we're getting towards the end of evidence, and it was looking like more people believed her than him. And that's what it is. It really gets down to the testimony of the two of them. And he's also disadvantaged because he says, I can't remember part of it. So, well, it was her testimony against and the ski instructor versus him and his friend. Jury didn't believe him. Jury believed her. And this is one, it's interesting. They certainly made a prima facie case. If the jury believed that doesn't mean that he wins, but if the jury believed his version, they certainly would have been justified in awarding damages on his behalf. But the facts of the actual incident were so murky. I can't imagine the jury doing anything that you could fault. They went all in, full team goop here. They found for her as a defendant and as a plaintiff, and the dollar thing, that was just to make it easy. That was actually good tactics on the defense part. I'll give him that. I thought that could play the other way. It's sort of like, oh, I'm above, money doesn't mean anything to me, and it's sort of condescending. But the jury didn't read it that way. That's fine. But once you do that, give somebody an easy option. They're looking at this going, I'm not sure who did it, but I'll tell you what, I don't want to do math. That has more power than you think. I'm being slightly facetious, but not really. Not really. So, I mean, I could see this all day long was a defense verdict. I didn't know that they would award her the damn dollar. But even if they just, if it's just a defense verdict without the dollar, they're entitled to ask for costs and attorney's fees. At least they are in Illinois. Probably, I don't. Their civil procedure seems so darn similar to Illinois. It's hard for me to tell a difference. We don't use 8 jurors, but that's, whatever. That's not a big deal. They just have a little different rule there. But all the other stuff they were doing, very similar. Reminds me of going to work myself right here. Right here, because I'm just a simple country attorney right here. I'm in my little Midwestern outpost on the plains. Toiling away, practicing some law. So, there we go. Dr. Evil didn't get it done. Gwyneth Paltrow, with her legal team of Spread Eagle and Clark Kent, carries the day. All right, you guys. Thank y'all. And this was kind of good. Whoever pointed out in the comments, they said, yeah, I was doing it and I was kind of sitting around here. I have to sit around here anyway to monitor. And someone said, well, why don't you just turn on Manning? She's going and it's already getting crazy. That turned out to be kind of fun. So thank y'all for coming out. I will see y'all soon.